Good morning and thank you everyone for joining us for today's webinar, Massachusetts Paid Family Leave and Medical Leave Review for Employers. We will be getting started shortly, but at first I wanted to take a couple of minutes to go over the format of today's webinar. All phones have been placed on mute for this webinar. If you have any questions throughout the webinar, please use the questions tab in the menu. We will address questions at the end of the webinar as time permits. Any questions we don't get to on the webinar will be sent to the presenters to follow up on. We will also be recording the session and the recording will be sent out after this webinar. Again, thank you for joining us, and at this point, I would like to introduce our presenters. Amy Allen. As a partner with Bloom, Amy Allen leads our human resource consulting practice, where she focuses on working with clients on the people side of their business. She has over 25 years of experience in HR, including holding leadership and executive roles at Suffolk Construction, the Boston Globe, Planned Parenthood, Staples, and other large national organizations, before launching her own consulting business. At Amy Allen Human Resource Consulting, Amy provided HR services to her clients both as an outsourced HR department and on a project basis. Lisa Zaccardelli. Lisa practices in all areas of civil litigation, with concentration on employment law litigation. A substantial part of her practice includes non-compete business tort and trade secret litigation cases. Lisa routinely works with employers on matters related to disputes with their employees, including immigration matters, ADA and FMLA claims, wrongful discharge, breach of employment contracts, unfair labor practices, and wage and hour disputes. At this point, I'd like to turn it over to Amy Allen to begin this webinar.
Thanks, Carly. Good morning, everybody. Happy Wednesday as we all continue to manage through the pandemic, and for those of you in the Northeast, prepare for a snowstorm. Seems like the kicks in the teeth just keep on coming, and I'm sure that talking about paid family medical leave is exactly what you are all anxious to do today. But nonetheless, it's a really important topic for us to cover because we are on the heels of the 2021 ability to file claims. As we know, there's been so much attention focused on COVID and the challenges that we're facing as employers. And because of that focus and those challenges, the concern from our practice, and certainly I think Lisa's getting inundated, some of us feel very unprepared for the launch of the Massachusetts Paid Family Medical Leave. There are certain areas of this new regulation that are complex. There's also potential risk that could present compliance issues for employers if the issues are not properly understood or adhered to. The other important thing to know is that we all are in this. There's no exclusion for this regulation related to the size of the company. All employers are subject to paid family leave in Massachusetts. So as I said, we're all in this together. Next slide, Carly, thanks. Here's the agenda for today. We're going to obviously give an overview of the leave itself. We're going to talk about responsibilities as employers. I get a lot of questions from clients about the benefits of going private versus going through the state. We're going to talk about private plans and when to consider them and what the difference is. We're also going to talk just quickly about the employee experience, what employees need to do in terms of applying for this paid leave. A lot of questions and complexities around the interplay between the paid leave and other leaves of absence and other benefits like short-term disability and paid time off. So we're going to run through some of those scenarios and talk about how how these leaves can be interchanged or work together. This is going to serve as a reminder with regards to job protections and no retaliations. And we obviously, as Carly said, will leave some time at the end for questions. If we don't get to all the questions, we of course will follow up after the webinar. Here's what we hope to achieve in the next hour. We want to explore some of the most important aspects of the paid family medical leave, including our responsibilities as employer and potential risks. We also, as with all of our webinars, want to provide some practical tips and some best practices and strategies and thoughts to prepare and administer the leave. And I'll turn it over to Lisa to give us an overview.
Good morning, everyone, and thank you so much for your attendance today. And as Amy said, the law is complex, and there certainly are some risks. And when you have specific questions about the application of this in real time, which I'm sure many of you will, it's always best to seek that specific advice and counsel from either your human resource professional, someone on Amy's team, or your legal counsel. So the Mass Paid Family Leave, what is it? What is it specifically? Well, it is temporary paid job protected leave for eligible workers up to between 12 and 26 weeks under certain specific enumerated circumstances. So the family leave portion of the bill up to 12 weeks is for the care for a family member for a serious condition, bonding with a child, in the first 12 months after birth or after adoption or foster care, managing the family affairs when a family member is on active duty in the armed forces, and up to 26 weeks of care for the injured service member, along with medical leave of up to 20 weeks while the employee is unable to work due to the employee's own serious health condition. Who is it available to? It's available to both W-2 workers who work in Massachusetts, whether they're full-time, part-time, or seasonal, as well as this 1099 miscellaneous contractors. And that might seem somewhat counterintuitive, but the law does provide for 1099 miscellaneous contractors to be covered if the employer issues 1099 miscellaneous forms for more than 50% of their workforce. Self-employed individuals can also opt in to the program, and they're not required to comply with the law, but may voluntarily elect to pay contributions in order to get coverage. How do you determine whether someone is, whether as an employer or an employee, you would be contributing to the paid family leave? Well, it's based on the unemployment statute. So if you are, and we'll go through the test a little bit later on, but if you're making contributions for unemployment purposes to the state of Massachusetts, then that is going to be the determinant factor as to whether someone qualifies as being employed or excluded employment. And then finally, this entire system is going to be administered by the Department of Family and Medical Leave, and they're the ones that are going to be evaluating the forms, looking at the documentation, and determining whether or not someone qualifies for the leave. There are, of course, certain exclusions, and those exclusions sort of largely tracks unemployment exclusions. Some examples, and there is a laundry list of those exclusions on the mass.gov website specific to the Family and Medical Leave Leave Act, but specifically municipalities, political divisions, housing authorities, regional schools districts, real estate brokers, salespeople, and insurance agents that are in commission-only jobs, the paper boy or paper girl, work study, student nurses, and nonprofit public training programs, along with any employment by churches and certain religious organizations. So religious employment, those would be excluded from complying with the act. So when does this all start? Well, of course, contributions collected via payroll deductions actually began on October 1st, 2019. But the important dates that we need to remember now, and why many of you are actively thinking about this from both a strategic standpoint, from a human resource standpoint, and looking at all of these issues, is on January 1st, 2021, leave will be available for any up to 12 weeks per year for an individual who has seeking family leave to bond with the child newly born within the last 12 months, a service member related events, managing those family affairs while a family member is on active duty, and and those applications for child bonding in 2021 can be submitted as early as December 2nd of this year. And they will also be permitted up to 20 weeks for their own serious health condition and up to 26 weeks per year for the care of a family member who is a covered service member. So that leave is beginning January 1st, 2021. Commencing on July 1st, 2021 will also be available paid family leave benefits for those individuals caring for a family member with a serious health condition. And again, the maximum leave eligibility per year for all leaves is a total of 26 weeks. So this slide, and I'm not going to spend a lot of time on this slide, and this slide is something actually that mass.gov has put on their webpage. This is the way in which the total contribution would be made for employers of 25 or more employees being covered. And again, we'll talk a little bit about how you get to that 25 number, but this is effectively how the total contribution would be made between the employer share and the covered individual share, and that calculation totaling 0.75% of wages. And there is a quote contribution calculator that is on the website as well that you can utilize in order to determine what those deductions are going to be. And then of course, less than 25, employers of 25 or less, the effective contribution is based on having the employers with fewer than 25 are covered individuals who are exempt from paying the employer share of medical leave contribution. So the covered individual share that the individual would be putting in 100% for their medical leave contribution and 100% of the family leave, and that equates to a 0.378% of eligible wages. And again, determining that contribution amount is broken down based on how many employees you have in your total covered individuals are included in the total workforce. So a couple of things to remember when you're trying to determine that contribution amount and what gets you to that 25 or more employee level. It's based on the previous calendar year, and employers should reassess your workforce count annually, especially if you hover around that 25 or more covered individuals number. And it's important again to remember that all W-2 employees will count as covered individuals, including yourself if you own a business and pay yourself as a W-2. And those 1099 miscellaneous contractors also count towards the total number of covered individuals, but only if they make up more than 50% of the total workforce. Again, it is important that you have a leave administrator contact info on file, because if you have questions and you need to reach out, you want to have that information readily accessible. And now I'm going to turn it over to Amy.
Thank you. And Lisa, please jump in at any point if you have anything to add that I might have forgotten as we go through this. But really quick, with regards to employer responsibilities, a lot of this information should have already happened, but we just wanted to serve as a reminder. Harley, you can go to the next slide. Thanks. As Lisa referred to, you want to determine your workforce with regards to that 25 employee calculation. And then you can use the mass.gov contribution calculator that she referred to determine the contributions. Again, all of this should have already happened within your work environments, but serve as a reminder, this is where you go to get that contribution calculator and figure out what your contributions need to be. All of the contributions are remitted, all of the contributions are remitted through Mass Tax Connect. If any of you have not already been on the Mass Tax Connect website and signed up, I encourage you to do that so you can make sure those contributions are going in smoothly. And another really important component to the compliance here is you need to notify your workforce. The notifications were required prior to 2020. So as I said, most of you have probably already hung the posters and sent the emails informing your workforce about the new deductions from their paychecks, and put the posters up about the fact that claims can start to be submitted as early as this month, actually, but for payout in 2021. So as I said in the beginning, we want to touch quickly on the option for private plans. As a part of the Bloom HR advisory team, we've been working with clients a lot on the difference, why to consider a private plan versus going through the state. So let's take a few minutes to walk through that. So there are private plan exemptions, meaning that employers can select to go through a private plan versus submitting payments to the state. Employer exemptions from collecting, remitting, and paying through the state contributions are allowed, as I said, through private plans, but those plans must be approved by the Department of Paid Family Leave, and they must be equal to or more generous than those provided under the state offerings. There is a list of approved carriers. Sun Life, Hartford are two that have been popular with our clients, but there's a list on mass.gov of all of the insurance approved carriers. You can apply to get this private plan exemption through Mass Tax Connect, and you're typically notified within 1 to 2 business days if you are approved. If you are approved, a private plan can take effect in the quarter following your approval. You also can apply for self-insured plans. Employees retain all of the same rights as if you were going through the state in terms of appeal and job protection and the no retaliation under the state plan. But these private plans are a part of your annual renewals and will be subject to premium changes, et cetera, with that renewal. One of the questions that comes up a lot for us is what are the benefits of a private plan? I encourage for any of you who have a short-term disability plan with a carrier, many of those carriers have been excellent choices for private plans or worth connecting with regarding private plans, because the ease of administration is just one huge benefit to considering private plans. The carriers really do take a lot of the burden off of the employer or the employer's HR team when it comes to administering the conditions of the leave. There's also slightly more control over the premiums, whether it's a self-insured plan or not. You have the ability through the annual renewal to talk about those premiums. So those are some of the benefits of considering a private plan, and particularly with those carriers that are approved already through the state. But if you are going through the state, let's talk about the employee experience and their application process. It's important because we know that our workforce is going to come to us to ask the questions about how they apply for the benefit and what the application process is. So we want to make sure that we cover that. The way that I've been explaining it or talking about it with most of our clients is to think about this a little bit like unemployment. The employee, if you're using the state benefits, the employee applies directly through the state. They can't apply any earlier than 60 days prior to the anticipated leave, but must provide the employer with at least 30 days notice. That's as soon as practical. Obviously, if someone has a slip and fall or a sudden illness, there's only so much we can control with some of these reasons that we're going on leave. But there are some guidelines as to the notice time. The state will ask for supporting information. All that documentation can be found on the mass.gov information page on paid family leave. Some of the requirements will depend on the nature of the leave and whether or not there's any additional wage replacements that the employee will be receiving. But those documentations, again, very similar to applying for unemployment can all be done through the website. Once an employee has submitted an application, the employer is notified within 5 business days. So the Department of Family Medical Leave may request additional information, and the employer must respond within 10 days. Again, this is a similar situation to unemployment. We will get, as employers, information asking about wages and dates of employment and other verification information. Employees are notified of approval or denial within 14 calendar days, and after they've received, that's assuming that they've received a complete application. And the employer is notified within 5 business days, as I said in the previous slide. One of the things that I wanted to point out, and that Lisa and I have talked about recently, is all of this is the promise, made by the state, but we just don't know how this is going to go. All of us have experienced the challenges that the state is facing with unemployment itself. I think it will be interesting and sort of remains to be seen how quickly these claims are going to be processed and how much the state has the appropriate resources to be able to process things in this committed time frame. So although these are the guidelines and sort of the targets, I think we will all just have to wait and see how successful or efficient or quick the state is with processing this. So big question mark about how well this is all going to be managed. So if the leave is approved, both the employee and employer are notified, and they also have an obligation to notify the state within 7 days of any changes in circumstances that would result in extension or modification or reduction of approval. So, important to know all of these timeframes as an employer, that you're required to reply to the state with regards to any claims that are submitted, your obligation to notify the state if there are any changes. Of course, all of these timeframes are different, whether it's 5 days, 10 days, or 7 days. But just be conscious of the requirements when it comes to notifying the state related to either claim submission or any changes to the claim. Fitness for duty may be required for return from a serious health condition, but as long as that's uniformly applied for the same reason, we want to make sure that you are consistent with how you're approaching fitness for duty. Here comes the confusing part, and as an HR professional, the reason that I like to stay away from numbers is because of the next 2 slides, but I'm going to do my best, so bear with me. So when it comes to the state, there's a 7-day waiting period before the benefit kicks in. Employees are allowed to use paid time off to cover those seven waiting days. I also wanted to point out that if you do have a private plan, that waiting period can be different. Some of those private plans can have a 14-day or even a 5-day waiting period. So make sure to understand, if you are in a private plan, what the waiting period is. But even with those private plans, employees can use paid time off to cover for the waiting period. But the way the state calculates the payout for the benefit is they use the state average weekly wage. That state average weekly wage is $1,431.66. No reason to round up and make that simple, but that is the average weekly wage. If an employee, they pay 80% of that state average weekly wage up until the maximum of $850. 80% of the wages, and then if you make more than that wage, it'll be 50% beyond that. But the maximum that anybody can get paid out is $850 per week. So no matter what you make in comparison to that average weekly rate, the $850 maximum applies to everybody. Couple key points, and this is a question that I talk through with clients all the time. This benefit can be supplemented by short-term disability or can be supplemented by an employer's specific parental leave policy. So if you currently have a parental leave or a maternity leave policy where you pay employees to be out for the birth or adoption or fostering of a child, you can supplement that $850 per week maximum with those benefits. What can't happen is employees can't collect that maximum and collect PTO at the same time. So it must be one or the other. Again, it can be supplemented, but can't be double dipped, as they said, where you're using your vacation time and collecting the weekly maximum. So if that isn't as clear as mud, here's an example. You don't need to talk through these specific numbers, but you guys will all have this slide should you need it. The key number, as I said, is that 1431.66. The 80% of that 1431.66 is that 715.83 number. The state will pay 80% of that, and then any difference will be paid out at the 50%. So this is the example used for someone who's making $1,000 a week. If any of you want to have help calculating this, there's help on the website, and certainly I can help, but this is an example and certainly proves or validates that average weekly wage is the key number when it comes to calculating what an employee will be eligible for in terms of payout. Lisa, before I turn it over to you, is there anything that you'd add into those sections that I just covered?
Well, there are a couple of things that I just wanted to note, especially when you were talking about sort of the possibility of how quickly the department is going to be able to act on these applications. And we expect and anticipate there will likely be a flood of applications very early on into the system because individuals are already struggling financially. They may not have certain benefits available to them. And so we expect there will be a flood of those applications. And so what I would just, what we've told employers is to be flexible with some of the, there are these deadlines, there are anticipated, when they're supposed to provide notice of the application, when the benefit's supposed to kick in. But again, the person is seeking a leave of absence based on either their own serious health condition or the birth of a child or connected with a service member. And you just need to be very cautious about any sort of claim of retaliation because of that application process and potentially a delay in that process. Again, we just don't know how effective this bureaucracy is going to be in administering the benefit. So that was something that I thought was important to highlight. So I think we could go, Amy, to the next, which is the interplay between paid and unpaid leave benefits. So, so this is certainly something that as employers, you need to keep in mind. Specifically, merely because you are making sure that you're compliant with the Paid Family Leave Act, there is still all of these other obligations as an employer that you may need to be abiding by. And the interplay of those is important and something that you should recognize and remember. So, of course, the first is Massachusetts parental leave, which is unpaid job protected leave up to 8 weeks. And of course, it's general neutral. And while you may have a separate paid parental leave policy, that job protection, those 8 weeks, still is there. You still must, as an employer, comply with that. And that parental leave is available for the birth or adoption of a child. The employee must have completed the initial probationary period, which can be no more than 90 days, and it covers 6 or more employees. So this particular law covers the very smallest the smallest employers in the state, and that is still there and available and provides job protected leave. And of course, then you also have family medical leave, the FMLA, which again is unpaid, but is job protected leave. And so this might actually come into play specifically where as an employer, potentially you don't meet the 50 or more employee threshold to be required to be providing that job protected leave. But you may be that 25 or more employer, or under 25, where you're still going to have individuals who will be allowed to access paid family leave and have that benefit. So again, family medical leave is unpaid job protected leave up to 12 weeks, and of course 26 weeks of caring for covered service member. And that family medical leave is still there. It hasn't gone away, and it's not going away anytime soon. And it covers the birth or adoption or serious health condition of the own employee or family member called to active duty. It kicks in when an employee has been there for 12 months and worked a total of 1,250 hours. And again, that determination of what employers are covered is 50 or more employees within 75 miles. So that gets into the whole question of if you have an employee who is working in Arizona, but reports into the home office in Massachusetts, whether that employee in Arizona is within 75 miles of 50 or more employees to be covered under the FMLA. It doesn't mean, though, that that employee might still, even if not entitled to FMLA leave, meaning unpaid job protected leave, might not still be able to access paid family leave, because that individual employee reports into and is controlled by a work site in Massachusetts. So again, a couple of reminders that are important to remember. There is that 7-day waiting period. And during that 7-day waiting period, the employee can access their PTO time. The exception, of course, is when when family leave is there to bond with a child and immediately follows the medical leave for childbirth. But again, the way that the law is specifically implemented right now, until we get some additional comments or guidance from the Department of Labor, is that the individual cannot use, and in this case, the employee cannot use both accrued paid time off at the same time that they are accessing the paid family leave. So again, this concurrent, it must be one or the other. The question of whether someone could make an application for their serious health condition, or for example, let's say with respect to the birth of a child, access that leave for a period of 8 weeks, and then decide to access PTO time after because they are experiencing a serious health condition. It's unclear whether the employee could then access their PTO time and not take advantage of the paid family leave in that circumstance. The conservative approach on this is that they can't use both, but again, it's not clear whether after that initial paid family leave benefit was paid for that 8 weeks, whether the employee could then try to use their PTO time for their own serious health condition. And it's just something to keep in mind. Can there be reductions to those paid family and medical leave benefits? The short answer is yes. Those paid family leave benefits may be reduced by certain governmental benefits, like unemployment, workers' compensation coverage. So someone could be getting paid under workers' comp because they have a work-related injury, which is also a serious health condition, which would be allow them to apply also for paid family and medical leave benefits. And those benefits, paid family leave benefits, would be reduced by those workers' compensation benefits, or when you have that long-term disability claim. that permanent employer, permanent employer disability program under long-term disability. What those benefits cannot be reduced by is temporary disability. So those paid temporary disability benefits connected with an employer temporary disability program, unless, and as Amy mentioned earlier, the aggregate, what the individual is getting from the paid family leave and what they would get under short-term disability, unless the aggregate exceeds the employee's average weekly wage, then there may be a reduction. So this is also sort of an area where there still is, a bit of unknown. But in order for the employer to seek reimbursement from those benefits, the employer may be reimbursed if the employer has made certain payments to the individual that are equal to or greater than the paid family benefits. And if, again, those benefits are in the form of short-term disability, paid medical leave, extended illness, separate and apart from any PTO time that we already talked about, an extended illness leave bank, but again, only and could seek reimbursement for those payments. How that mechanically is going to work, the information that the employer is going to have to provide, how the department is going to be able to reconcile all of that is really still obviously an unknown, and some of this it will be done in real time. Again, what I would advise is, to the extent that there are questions or you are concerned that the reimbursement request is not being handled efficiently or effectively, that you seek out counsel to get guidance in that. So some other really important factors to remember, intermittent and reduced leave, and all of you who are have to comply with Family Medical Leave Act understand the nature of what we were referring to in terms of intermittent or reduced leave. Someone has a medical condition which requires them to take time off on an intermittent basis. Well, the paid family leave also applies to allow individuals to access paid family leave for intermittent or on a reduced or intermittent basis. What are the circumstances under which that can occur? Well, intermittent leave can be applied for in a benefit paid with respect to child bonding, the birth or adoption connected with a birth or adoption of a child, but that's only if there is an agreement by both the employer and the employee to apply for that leave. So an individual cannot seek child bonding paid leave unless the employer and the employee agree that that's permitted. Other family leave, serious health condition, again, with a healthcare provider determination, that healthcare provider has to provide documentation that the individual is in need of intermittent or reduced leave. And again, I'm sure many of you are familiar with this if you have to handle this in connection with FMLA leave claims. The documentation is important in order to assess a qualified exigency. The individual's own serious health condition, if again it's medically necessary and not unduly disrupting business operations. The concept again of unduly in the law is is somewhat of a heightened burden. So just like when an employer has to make a determination as to whether or not they can grant a reasonable accommodation under the ADA, and the employer has to assess whether or not it is going to create it's an undue burden and cannot make that reasonable accommodation. That's a pretty high burden to meet. And it would be the same here, saying that an individual's own serious health condition cannot be accommodated on an intermittent basis that would not qualify leave because it would unduly disrupt business operations is also a high burden. And again, this is one of those areas where if you have some concerns, you should seek counsel on that question, because the analysis and what questions you need to be asking internally would be important. And the other piece of it is that employers should notify the department if the schedule is not adhered to. So by way of example, if the individual has indicated that they are seeking leave on as low as an hour block a day, so potentially an individual needs to take 2 hours out of their day to rest because they experience significant debilitation with migraines, and that is not being adhered to. That schedule is not being adhered to. The employer is allowed to notify and should notify the department of that fact. But and discipline in any circumstance, and we would be talking about this, whether it was paid family leave, whether it fell under the an ADA issue, or whether it fell under an FMLA. Discipline, it would be permitted and is specifically indicated in the statute and in the regulations. But again, anytime you are going to discipline an individual because they are taking a leave, and that leave is job protected, you want to make sure that you are not in some way retaliating against that individual because they've taken that leave. And so just like any other analysis that you might make on this issue, the same applies here. So just quickly, a couple of other points to remember. The weekly benefit for intermittent leave is reduced proportionately. So that would mean that if an employee was taking 2 days during the week, that the leave benefit would be reduced. They wouldn't be paid for the entire week. They'd be paid on a pro rata basis, and that's how it would be calculated. In the event that the individual's work schedule varies from week to week, the benefit is calculated based on the average number of hours worked from the 2 highest quarters of the 12 months preceding the application. So, many of you have probably confronted this when you're dealing with FFCRA or other kinds of leave. And so just important to make sure that that benefit that benefit is being calculated correctly. And again, intermittent leave counts against total allotment. So it counts against that 12-week or 20-week or period. And now I'll turn it over to Amy. And now I'll turn it over to Amy.
I apologize. So I was on mute. Classic pandemic error. Sorry about that, Lisa. There's one thing that I did want to highlight that you mentioned in this section related to taking the paid family leave and then being able to take additional time under PTO. This is a challenge that we've been discussing with clients recently, as the concern that people could take up to 18 or 20 weeks by using the paid family leave and then following up with paid time off. So as Lisa said, a lot of this is still to be worked out. But at this point, correct me if I'm wrong, Lisa, there's nothing in the paid family leave benefit that says that people can't follow up with PTO.
Correct.
So, at this point, it looks like there is a potential for individuals to be able to use additional time. One of the things to consider, and as Lisa said throughout the session, please get the advice of counsel, but could consider changing policies around taking PTO and approval of PTO. But doing that is, has risk to it, because if you have anybody that submitted a claim for paid family leave and then you go and change your paid time off policy, that could potentially be seen as retaliatory. So, be very careful with changing policies after somebody has submitted for the leave. Certainly considering changing policies now before you've had an employee submit a claim is potential, but definitely get the advice of counsel. So let's go through the next section, which is just reiterating what Lisa pointed out with regards to job protections and no retaliation. For those of us who are in HR or who are employers, we hear this no retaliation, this no retaliation clause, for lack of a better word, with a lot of labor law protections, and this isn't any different. So when any employee is out for unpaid medical leave benefit, they must be, when they return, restored to their previous position or to an equivalent position with the same status, pay, employment, benefits, length of service, credit, etc. This is exactly the same as the federal family medical leave, that the job protection means that they have to be put into an equal, the same position or equal position. There are exceptions that we mentioned here, including layoffs that you all, I'm sure, are aware of. When it comes to benefits during leave, again, exactly the same as FMLA. The employer must continue to provide for and contribute to employees' employment-related health insurance benefits. For those of us who have employee contributions, those can be collected during the leave in order to maintain those benefits, or they can be collected when somebody returns from leave. A lot of our clients, have a payback process in order to collect the employee portion of premiums, but those benefits cannot drop during when somebody's out on leave. They must be kept at the level and under the same conditions. Obviously, if an employer is going through a benefits renewal, then the employee who's on leave needs to be notified, and their selections need to be made during renewal. So you can't make assumptions when somebody's on leave unless you have a auto enroll or an auto carryover, but just make sure to not forget about employees who are on leave status. If you're going through renewal with benefits, that their coverage needs to continue and they need to be able to make the same selections. Employee contributions during leave should be consistent with existing policies, as I said. However, you administer those contributions during leave, make sure that they're consistent during this paid family medical leave. One question that's come up a lot to me is, what about paid time off? Paid time off does not need to accrue during leaves. That's true of any unpaid leave, and Lisa can correct me if I'm wrong, but I'm assuming that although nothing is pointed to specifically, paid time off accruals can be halted or paused while somebody's on leave, but then need to pick right back up when they come back.
Right, correct.
More on no retaliation. It's unlawful for employers to retaliate, threaten to retaliate, or discriminate in any way. What this means is any negative change in the seniority, status, employment benefits, pay, or other terms or conditions of employment during an employee's leave or within 6 months of returning from leave is presumed to be retaliatory. This is gray for a reason, and the concern from an employer perspective is around poor performance. And obviously none of us have any intention of retaliating ever against any of our employees for any reason. But we do need to have the opportunity to manage poor performance or manage individuals in terms of their meeting job expectations. We can go to the next slide, Carly. Another definition: such a presumption shall be rebutted only by clear and convincing evidence. So when it comes to that, meeting job expectations or managing poor performance, what the state is saying, and this is not different from other labor law definitions, it's clear and convincing evidence. How that is defined is yet to be seen with regards to paid family medical leave, but I can assume safely that it's going to be very similar to the federal Family Medical Leave Act, the federal statute, that all of this is going to be dependent on having good documentation. And if you think about poor performance in particular, the bottom line is any kind of performance management needs to be very job specific, needs to be performance related, and needs to be documented. And if anybody has been out on leave and you need to manage their performance, again, the advice is to really make sure that you seek counsel so that you don't fall into the retaliation category.
Amy, can I just make one point on that?
Please.
So just, you know, as a litigator, whenever I see the word clear and convincing evidence, I know that the burden of proof for the employer is extremely difficult, because clear and convincing evidence means overwhelming evidence that the decision was not in retaliation, but that there was you know, they say sufficient independent objective evidence regarding the restoration or any of those issues concerning performance. And clear and convincing is more than what we refer to as a preponderance, sort of tipping the scales. So it really does, it would really, to Amy's point, need to be very well documented, and also, you know, it couldn't simply just come up necessarily while that individual is out on leave. So it's, of course, these are all fact sensitive questions, but the concept of clear and convincing evidence is a very difficult burden in the law to establish, and I just think it's important to remember that when you're making these determinations.
Great, thank you. Next slide, Carly. Thanks. Just to reiterate, clear and convincing evidence, as Lisa just described, our recommendation is to make sure that your performance management systems, whether that's performance review, performance improvement, progressive discipline, that managers are trained on how to manage performance, that policies are in place and consistent, supporting any kind of employment or disciplinary decisions, and of course, to document. So I think that brings us to our final thoughts. Lisa, do you want to take us through the next couple slides, and then we'll field any questions? Or the next one slide? Next slide,
sure.
Carly.
I think, Amy, those next, yeah.
Oh, I apologize.
Right.
That was one more.
So I just certainly had a couple of thoughts. Again, I think we've sort of said this a couple of different ways and a couple of different times, but I do think that employers should be prepared for a flood of claims, that there will be a significant number, I think, especially in light of the pandemic, the continuing nature of the pandemic, the COVID, the fact that individuals may feel at risk to be in the workplace due to the still COVID-19 pandemic. And so I do think that that is something to be prepared for. And I also think you also have to be prepared that there's going to be a learning curve on all of this. And it's important to, you know, not get too exercised over some of these issues, and to just recognize that the learning curve is not just on employers, but also probably the department as well.
Yeah, and I just wanted to take a second to reiterate what we're recommending that employers do now. So you all certainly want to ensure that your PTO policies and handbooks are up to date, and that employees are being properly notified about the paid family medical leave. You want to align your other leave benefit processes and administration so people can know how they might be able to supplement leave or how leaves are going to work together. Certainly make sure to inform and train managers and anybody who is supervising others on this new regulation, and particularly related to managing performance when somebody returns from leave. encourage anybody who hasn't explored private plans to explore that private plan insurance, and just know again that the mass.gov Department of Family and Medical Leave website has a plethora of resources and knowledge, and encourage you all to look there for any information or documents or notifications, template communications, all those kinds of things are listed there. Carly, how do you want to field the questions? Do you want to?
Yeah, no, I can. We have a couple minutes, so I can. Let me bring it up quick now, and then I can. First couple of them I can give out, and then the rest we don't get to. We'll make sure that you and Lisa receive them later on. Okay. So here is one. Does the employee have to accrue paid time off during their leave? Can you make changes to the employee handbook so that the paid time off does not accrue?
Yeah, so I think we answered that one. The paid time off does not have to accrue during paid family leave, similar to any other leave. Certainly can change policies. Just be careful not to change any policies, after someone has submitted a claim that might be seen as retaliatory.
Awesome.
Yeah, and I just would do one more follow up on that. Certainly that to Amy's point, I think that's important. You wouldn't want to change it in between, and you want to just make sure you're applying the policy consistently and uniformly. So if you're not typically accruing the PTO during that time for other leave, then you likewise would do the same. But you don't want to make inconsistent applications of your policy.
Mm-hmm. Employees in Massachusetts, employer lives out of state. Employer has not made any contributions or taken deductions. Can Massachusetts residing employee access the Massachusetts DP FLM benefits?
So I can take that, Amy. If the employer is not making contributions for unemployment purposes for that employee, that would be how you would track whether that employee would have access to those benefits.
Perfect. And then we have employees who live in Pennsylvania and Maine but work for our facility in Massachusetts. Are they covered under the Massachusetts Paid Family and Medical Leave?
So that's the same analysis. Again,
Yeah.
The analysis of whether someone is an individual and considered a Massachusetts employee is based on, again, unemployment insurance purposes. So if the employee is working in Massachusetts and that's where they're providing their services and you're making unemployment contributions, which again, this is an analysis that sometimes employers haven't made, and it is important to make. But the determination again is where the services are being performed. If you can't make that determination, then where the base of operations is. If that's not clear, or if it's in multi-locations, the place where the employee gets direction and control. So in this case, it would seem that the employee either is providing all their services in Mass or is getting direction and control from Massachusetts. And likely that individual would have access to the benefit because you would be making unemployment contributions for those individuals in Massachusetts.
And I would just add that I would assume that someone is qualified if they're performing, as Lisa said, they're performing duties in Massachusetts despite where they live. Certainly you could reach out to the department to ask the question, but I would safely assume that they would qualify and you should be making contributions on their behalf.
Yeah, I would agree. And I think sometimes where this might raise an issue is if you haven't been making unemployment contributions for that individual. So you may need to align those, but absolutely, I agree with Amy on that.
Perfect. So I think we're just out of time now. Thank you again for Amy and Lisa as well as everyone else for attending this webinar. And any questions again that we did not get to, we will email them out to Lisa and Amy as well to get those answered. And the recording will also be sent out after this webinar as well.
Thank you, everybody. Thanks, Lisa.
Thank you. Thank you, Amy. Thank you, everyone.
Thank you and have a great rest of your day.